All right. Again, thank you so much for being here today. I'm excited for you to listen in about artificial intelligence, a very hot topic at this moment. And I'm very excited to have Matt Groves with us today. He joins us from Copic and joined in 2023 as the General Counsel and Compliance Officer after more than 27 years in private practice, which included many years of working with Copic on various issues. His background includes a broad range of legal expertise in various areas of corporate law and governance, including significant experience representing healthcare providers and healthcare systems. His practice included extensive federal and state corporate litigation and trials in multiple jurisdictions. He oversees Copic's various legal and compliance matters, in addition to advising the CEO and the board. And Groves also received his Bachelor of Arts from Boston College and obtained his Juris Doctorate from Loyola University of Chicago. So again, we're very excited to have you here today to walk us through a very dense topic. So that is all that I have for housekeeping. I'm going to go ahead and hand things over to you, Matt, and have you take it from here. Thank you so much.
Let me just confirm you can see the screen. Did it share?
Yes, we can see it.
Okay, I'll get going. Hello, everyone. Thanks for attending. I have, but more disclaimers. This isn't legal advice. This is informational, etc. But as I was saying to Christina, if we don't have enough time for questions after, I just do want to make it clear. Please reach out to Christina with questions that didn't get answered, and she will get them to me, and we will get them answered because that is supposed to be part of this today. Just to give you a little background as to why it's me talking to you. The dark green states here are states where we insure hospitals and physicians. That's all we do. We are the number one writer in Iowa. We insure slightly less than half of all physicians in hospitals in Iowa. So I'm coming to you with those dark green states are where we're admitted. The light green states are where we write elsewhere, and we track AI and various things, various legal topics, but what we're talking about AI in all of those states. And so that's what I'm coming to you with, but also with Iowa specifics. So what we're going to talk about is where are we seeing liability, how, and how to protect yourself from liability and what's coming in the future, broadly speaking. So let me jump in. What are we seeing in terms of claims against healthcare providers with respect to use of AI, right? Surprisingly, what we are not seeing is malpractice claims with people claiming you inappropriately used AI or you failed to use AI or what have you. There are no reported cases in the United States of America about a physician using AI and that in and of itself being the source of a malpractice claim. Certainly some of our claims involve cases where AI was used, but it has not been a reported case yet, which is just as surprising to us and all of our industry colleagues. We all talk to each other and track this very closely as I assume it is to you. The litigation that is occurring so far in the AI arena in medicine has to do primarily with privacy claims, with how the information gathered by healthcare providers and healthcare systems has been used and how it has violated various privacy laws and provisions. And so I'll start there, right? So let me just give you a big picture of what I'm talking about there. And we're going to go through. There are so many different statutes that hit on use of AI and hit on privacy, of which you're aware of before you ever heard the term AI, right? HIPAA being the primary one. But there's also state privacy laws, state statutory privacy laws, personally identifiable information laws, advertising laws, right? And so where the privacy litigation is coming down, and privacy being topic one here today, is failure to properly obtain the patient's consent to intake their information into an AI system, or failure to secure the information such that it was subject to a data breach, right? And so the lawsuit theories are kind of threefold here. One is you didn't get consent and the AI system used itself to use the data to train itself, which all AI systems do without their permission, right? In violation of some statute or privacy law. website issues, right? That the websites gathered information that may contain some PHI, protected health information is PHI, or personally identifying information, which is PII, the other big issue, right? And so that's why you may all have seen in the past year or so, every time you sign on to a website, that little accept cookies thing jumps up at the bottom, right? That little accept cookies thing is a reaction to state and federal laws trying to prevent websites from gathering your personal information without your permission, right? And if you just hit accept all, you've just given them permission to do that just for your own edification, right? And so that's what that is. So that's a source of litigation. And then data breaches by either your own servers getting hacked or you sign on to Epic and Epic gets hacked, right? But you're certainly under HIPAA laws, you're on the hook for your vendor getting hacked, right? And so these are sources of litigation that we see. So so just to give you, and this is specific to Iowa, we'll get into Iowa, but just as a general statement, you're talking about wiretapping laws, HIPAA, federal wiretapping, privacy laws, medical biometric data gathering laws, the AI statutes in various states, common law, privacy, consumer protection, and Federal Trade Commission regulations. All of these things come into play when you're talking about AI and AI gathering either protected health information or PII. And it is mind-numbing to look at that list, but there are some very simple ways you can protect yourself from these privacy claims, and we're going to talk about that. So what is the status of the AI statute? It is complete chaos. There was a brief glimmer of hope at the beginning of this administration that the federal effort to have a uniform AI law that would also govern the use of AI in medicine, in such that there would be one overarching federal structure on this, similar to HIPAA, frankly, that would pass. That got kiboshed. So what you have is complete chaos, frankly, right? You have 50 states, each passing their own AI statutes, or as the case may be, not passing their own AI statutes, and wild variants, right? And you even have variants in terms of the terminology, right? The term artificial intelligence is not universally used, right? You have artificial intelligence, augmented intelligence, like for instance, in the medical field, the AMA and others are saying we shouldn't use artificial intelligence because that connotates that it's replacing physician judgment. So let's call it augmented intelligence because it's just a tool that we use like any other tool. Probably an accurate statement, actually. And from our perspective as a liability insurer, that's exactly how you should think of AI. It is never going to replace you. You're always the responsible party, right? If you take nothing else out of today's talk, you are always responsible. The AI will not ever replace you and will not ever replace your liability. So that's the best liability protection anyway. But you'll see in the statutes are getting away from the title of artificial intelligence and more towards calling it what it does, right? So automated decision-making technology is a big in a bunch of statutes. You have automated decision system, machine learning, algorithmic decision-making. All of these various terms are talking about the same thing. So it's very confusing across states, and even professional societies call it different things. So there is no uniformity, and there will not be. I wouldn't think in my lifetime or anyone my age or older, we're going to see this chaos will continue, right? So the statutes so far are highly concentrating on protecting against discrimination and privacy. Where you see the statutes really are for instance, banking and finance not discriminating against minorities or any particular group, right? Where you see it in healthcare is that healthcare payers, health insurers aren't using it to discriminate. Right. And then obviously also to make sure that if you're using it, that privacy interests, PHI and PII are protected by statute. That is the concentration. So when it delves into medicine, which it really hasn't too much, the way these statutes are structured is the AI making an automatic decision without human involvement? If it is, then what you see on the right is like the California, kind of Colorado, New York example of huge government intervention into AI, right? That's like the worst case statute you're looking at on the right. And so these say, well, if it's making an automated decision, then you have to apply all these things, right? And so the concern is that the automated decision will have bias or discrimination built into it. And so the reason it doesn't get down into medicine is the one, there aren't that many programs that actually make the medical decision. We'll look at a few that do. But also it would bog down the practice of medicine to say, well, is AI involved in the decision? If so, there has to be human oversight. And so that's why medicine and HIPAA, the way they cut it out is usually HIPAA governed entities are cut out of a lot of these AI statutes. So, but this will just keep changing. So let's look at Iowa, right? Iowa is a light touch state in terms of AI governance and AI interference, or I'm sorry, governmental interference or statutory or regulatory interference in use of medical AI, right? So far, you've passed two statutes, which you just did a month ago, right? And what was passed a month ago was a prior authorization, again, so that you can't, the AI can't be the sole basis for a payor to make the decision, the prior authorization decision. It can just like medical AI can give a recommendation, but a human has to make the final call. That really has nothing to do with what we're talking about today. So then the second is chatbots, AI chatbots, and where it came into medicine was mental health chatbots, and they want to control that, and many states do that. Out of fear of teen suicide and things, and these chatbots, actually providing care and advice and taking, people with mental health concerns down the wrong path. So they put controls on that. Iowa has that somewhat touches on your profession, your thing, but not too much. Sandbox is being set up in some states, and we'll talk about Iowa's efforts in that regard. A sandbox is kind of a protected area, protected practice and use of AI, regulatory protected, immune from liability, but tightly controlled so that people can experiment with AI. There are multiple states allowing use of medical sandboxes, and we'll look at that. This year, there was an effort in Iowa to do that as well that failed, but generally speaking, if something is tried once, it keeps coming back. And so we'll talk about what you might expect in that regard in Iowa. So all that being said, when you see that list of statutes, how do you protect yourself from these privacy lawsuits? In Iowa, there's only been one. It was filed against the University of Iowa hospital system, and it was because of their website farming data from people using the website, farming PII and PHI and not protecting it. It got thrown out on some legal technicalities, but it was a class action, just like are being filed almost daily in California, in states that are way more liberal in terms of allowing those kind of claims. But it has been tried in Iowa, so it's not an ethereal concept. It's been tried in your state. So the way to protect yourself is first get patient consent to do it. That is the gold standard way to protect yourself. If the patient consents to you using their information and using it in AI, you've just gone 90+% of the way to protecting yourself from a privacy claim. And then you have to protect the information. And we'll talk about ways to protect the information the tight compliance is compliance with protecting the information that you do collect. Those are your two ways to avoid the privacy claims. So let's talk about patient consent. I wish I was looking at you all to ask you to raise your hands, but I will just say that we hear again and again and again and again. I don't need patient consent to record a patient or to use ambient AI in Iowa because Iowa is a one-party consent state, right? And people know that a one-party consent state is, the majority of states in the United States is one party can record a conversation with another party without that other party's consent. Some states are two-party consent states, California and other states. You'll see me pick on California a lot today. And so Iowa is a one-party consent state. Are you technically allowed to record a conversation with another person? Yes, huge asterisks. And let me just say huge asterisks why. And let me say right now, that is not a protection to you. Forget you ever heard that. Forget about one-party consent. And here's why, right? One-party consent, that issue applies to a little sliver of your potential liability, and it applies to the sliver of your potential liability that you likely would never see, right? It only applies one-party consent to a criminal wiretapping claim, right? That's it. Doesn't apply to any of the basis of the people being sued or the reason people are being sued and hospital systems are being sued for privacy laws. So get it out of your head that the one party consent. Yeah, you won't be criminally prosecuted for wiretapping, but I dare you to find anyone who's really been criminally prosecuted for wiretapping. That's very rare, right? Even if you do it, it's very rare. It's not something people care about. So all the other list of things, though, remain alive and well despite the one party consent state, right? So let's talk about that. You have invasion of privacy laws, right? So if you record someone without their permission, that is a what we call a tort. That's a civil claim, right? That's an invasion of their privacy. Even if you were allowed to under the wiretapping statute, they can still sue you for it, right? Consumer Fraud Act, depending on what you do with it. If you didn't tell them about it, it could be considered fraudulent. The Consumer Data Protection Act, which is like a first cousin of the Consumer Fraud Act, right? Then you have HIPAA issues with how you gather data and obtaining proper consent from a patient to gather data. You have federal wiretapping laws. You have breach of contract with your patient agreement. You have Federal Trade Commission regulations. Then you have in some states, Iowa, is it on the horizon? Maybe the how you store and collect biometric data. And then, of course, the AI statutes. Currently, your AI statute doesn't really touch this, but odds are somewhere down the road it might, right? So all of this again is back to that witch's brew. Good luck. You will spend, I've been in practice 30 years. I couldn't walk you through all of these without doing a lot of work. I can give you a lot on a lot of them, but they are Byzantine. HIPAA alone is Byzantine. Stay away from it. Get the patient consent and you wipe all of these off the table, right? It's very easy. And don't fall for the, well, that adds time to the patient visit and that. They've studied this. It adds virtually no time to a patient visit, particularly if you're using ambient AI because it's recording anyway and you get the permission right at the beginning. And virtually no one doesn't give you permission. Some patients will not. That's okay, but it is a tiny minority when people look at the statistics, right? And so do it right in the chart. Here is, a canned statement you can use. Some version of this is perfectly acceptable. There is no one way to do it, just like there's no one way to obtain informed consent, right? But it's this just informing them that you are, it's going into a secure system that's going to help you provide better care to them and it's going to help you have a better visit with them. That is the message. And the vast majority of people accept that, right? You won't get a lot of resistance to that. You will get some, but you always have some. There's some always percentage of people who are going to be disagreeable about something, right? But the vast majority of people, from what we see, agree with it. And then you record it in the patient's chart with a simple yes, no, they agree to it. If nothing else, as part of your admit forms, as part of your consent forms, your practice or your hospital consent forms, put the AI in there. And many hospital systems are doing that, right? But if you're in practice, get it into your practice forms at least so that somewhere you can produce a piece of paper, say, no, we told them that and they signed it, right? That is not as protective because you get people saying, well, I signed a bunch of boilerplate and I didn't look at all that. And that sometimes in court, that can be a patient can get sympathy towards that, right? To be like, well, you signed all this stuff and you were sick anyway and you needed the care, so you would have signed anything. So that's I would consider that secondary. Our recommendation for liability protection is get patient consent to record. So now let's switch gears to how do you address the second part of privacy, which is protecting the data, right? And so for many of you, this may be irrelevant, right? But for those of you who are in an administrative capacity, either in a hospital system or in your practice, or you're investigating AI vendors, right? You need to have these things, right? And today, you see all this the stuff I'm throwing at you. This is like speed dating, right? I'm trying to get you to issue spot and follow up, right? And so what you as the administrator, first things first, figure out everything in your suite of software products that uses AI. You'll be surprised at how many do, right? There's an AI component to most software now, right? And so things you didn't even think about might have it on there. You want to know what's using it, right? Particularly if Iowa gets to a more aggressive or more comprehensive AI regulatory structure. You want to know what AI you have. That's first things first. Then we're going to talk about vendor due diligence at some length because you're virtually none of you would be programming your own AI software. I can't imagine anyone on this call would, or anyone you even work with would, right? There's too many off-the-shelf products, Epic, you name it. There's things you have to look out for because all AI vendors will try and shift liability back to you and make you responsible for their breaches, right? You have to have internal policies about AI use. You should have good breach insurance, right? Cyber liability insurance, cyber insurance. That's cyber being the key term when you're talking to your insurance broker. Cyber, cyber, cyber. You must have cyber coverage of some type. I shouldn't say you must. It's not legally required, but it is. We certainly recommend it, right? And then monitoring. Once you have the systems in place, have some system in place. For instance, HIPAA requires it, and HIPAA will ask for, in the event of a breach, what was your monitoring? What were you doing to make sure your protections worked and were being complied with, right? So this compliance part is no joke, and it adds administrative overhead and cost. Don't know two ways about it, but that's not common to medicine. That's common to every company in the United States of America. So, okay, let's talk about vendor due diligence, right? You need to know if you're the administrator handling this, what is the vendor doing with your data, right? Are they training its models? Is it de-identified before training? De-identified being, are they scrubbing out the patient identifying information? Can you opt out of that training? You should if you can. And then what happens to it, right? Where are they keeping it, right? Particularly when we get into ambient AI, and I'll hit that again. What happens to the ambient AI recordings, right? Our advice is have a system in place. There's settings in the software to do it. As soon as you review the ambient dictation and approve it, get rid of the recording because there will always be a conflict between the final charting and the recording, and the plaintiff attorneys go right for the recording to see what was said, right? And what else was said and what conflict and what wasn't charted. Have one chart and not this risk of the recording having something that can be used against you, right? Just like the TV says, anything you say can and will be used against you, right? And I don't mean to be silly saying that, but it's true. So you want to know what happens to those recordings and find a way to get rid of them as a policy, right? As a procedure, a standard procedure that they're deleted. Make sure your website is compliant, right? If you have patient portals, patients signing in, make sure that your cookie structure and everything is compliant and that your website isn't bleeding data in a way that's going to get you sued, right? And your IT people will have to tell you about that. Know or hire someone who knows the data security frameworks, right? SOC, ISO, NIST, all of these, I can spell them, but beyond that, I have to rely on experts, right? And so, but you need to make sure if you're using the software that it is compliant with federal standards for security. And then do your diligence on the vendor, right? Every AI vendor on the planet says they've invented the wheel, right? All of them are the best, and all of them are going to revolutionize medicine. Hands down, they all have some version of that in their marketing program. But a lot of them are, a proprietary piece of software tacked on to a kind of a basic engine, right? A Claude, an Anthropic, a Chat, GPT, whatever. And then, a lot of them, I literally had a vendor say to me that we were going to use, what is this IPA you keep talking about? This was a vendor of software that we, a medical malpractice insurer, were going to, investigating using to store PHI. And the vendor, whose software was pretty good in terms of what it was, the service it was going to provide and the efficiency, did not know about data security. That is much more common than you think, right? So you're going to be responsible, right? If your data gets breached by your vendor. It's very important you know that. Under HIPAA, particularly, just to give an example, you're responsible. So you're the covered entity. So you need to make sure that they have security programs in place and that someone who knows what they're looking at assesses that. So,
Mr. Groves, we have a couple of questions in the chat here.
sure, yeah, interrupt.
All right. Do you think we need to get consent each time a patient visits? We have been having patients sign an acknowledgement at the front desk and keeping it on file. Some do refuse to sign it, so we don't use AI for those patients.
Good. I'll start from the back. That's that you don't really have any choice if they refuse, because if you record them after they refuse, you really just walked into it. I think that is okay. I mean, there is no one way to protect yourself. More is always better, right? And I don't mean to be too lawyerly, but if you could do it every time, fine. If it's one thing that they sign every time you come here, you're agreeing to use of ambient. If you maybe renew it annually or something, but something is better than nothing, right? So what you just described is protective of you, right? They've signed it, they've looked at it, right? And so if you have the sign on the office wall too, right? You've got them signing the thing, you've got the sign, remember you agreed to if you agreed to ambient AI, we're using it. Right. That's kind of what these signs say. If you agree to it, remember that we're using it. And then you can, at the beginning, while the ambient AI is recording, just remind them, right? And remember, you agreed and it's being recorded. So just more is better, more is protective. That's kind of, I know that's a lawyerly answer, but that's the best way. But to give the direct answer, at least do what you described, right? Have them sign something.
As a follow-up to that, would it be best practice to have that document called a consent form in rather than an acknowledgement?
That doesn't matter. That's semantics. But whether they've acknowledged or consented, they've agreed, right?
Okay,
That's the key, is have they agreed to use it?
perfect. Another couple of questions. Can you be targeted in court for deleting ambient AI recordings if it is one, routinely done, and two, to protect PHI from AI mining patient data without consent?
You've hit great question, great person. I love whoever asked that, right? That is the key, right? What the unspoken part of your question, but which clearly underpins the question, is you don't want to ever delete anything or change a medical record in the face of a lawsuit, for instance. Like you get sued and you go back like, oh, let's delete the AI and let's change the chart. Boom, you just lost your case. But if you have a standing policy, as soon as the dictation is approved, the recording goes away, right? And you have that policy, and within that policy, it says just what you said. I love what you just said. We're doing this to minimize the risk of PHI loss or breach. That is beautiful. I love that. Right. And so absolutely do what you just described. Right. And you definitely want it as a policy, because then that's not, when you get into court, what they call spoliation of evidence or destruction of evidence. Right. Because it was a standard policy and it occurred long before you would have known about any complication. Right. Or any lawsuit. And so that is exactly how you do it with the recordings. And then also, in addition to the policy, like check the software settings, right? The software can be set to that. In some systems, not all systems. In some systems, it can be set as soon as you approve the dictation, it's gone. So it's just part of the software package. Any others? Okay, I'll keep going. So here's the thing, and this is not me trying to pump up my professional colleagues here, but when you're looking at these vendor contracts, get someone familiar with the contracts. A couple of hours of attorney time can save you a whole lot of headache and money later, right? Make sure, because you got to look at some key issues that are not intuitive necessarily, even though you're all in the top percentage of smartest people in the country, right? You wouldn't be where you are if you weren't. There's a lot of nuance to this, right? And so their indemnification provisions, right? These vendors will ask you to indemnify them if they make a breach. Literally, those are in these contracts many times. You want to make sure the vendor has insurance, right? And where is your cyber insurance? And are any gaps in between? You don't want gaps in coverage. You want full coverage as a cyber event on their versus yours, right? And can you stack the policy so that their pays first before yours? All the vendors will try and limit their liability. If we get sued, if we breach, if we misuse your data, our liability to you is limited to the amount you paid us for the software. And that's like this much as compared to what your liability is for a data breach, or if HIPAA, the Office of Civil Rights, who administers HIPAA, comes after you. Trust me. So you want to get rid of those things. The warranties and the warranties for breach. What happens? And then SLA is a service level agreement. If you're using this software, any kind of software, the service level agreement is their guarantee of what's the uptime. 99.5, 99, what is it, right? You want to make sure that they're guaranteeing it, and you want to make sure that they have a procedure. What if it goes down? What do you do? You're totally reliant on this software and it went down. How do you practice? You need to know those things. Right. What's the breach protection? What do they have? Right. How are they storing it? What's their security? What's their cyber systems? Right. And then You have to have a business associate agreement under HIPAA in place with these vendors. You're the covered entity giving them their PHI. Having one in place offers you some HIPAA protection if they breach. That's a whole talk in and of itself. But again, this is issue spotting, speed dating here. If you're looking at these things, if you're the person in charge, make sure you hit these with someone who knows these issues. Okay, now let's get to what I think you all thought we were going to be talking about in the first place, right? So malpractice, right? How is AI factoring into malpractice? You heard my statement in the beginning that there is no reported case solely based on use of AI. That's a true statement, but asterisk that because a great many people are using AI, and as this slide shows, it's not going anywhere. We know damn well that in a lot of our cases, AI certainly it must have played some role, right? But it hasn't been a focus because just kind of cut to the chase, it's very difficult to tell if a healthcare provider actually used AI. Ambient AI, sure, the ambient dictation, but radiology, gastroenterology, cardiology, hard to tell exactly what the AI did and how the physician relied on it. So it's hard to sue on that, right? And that's the bottom line of why you're not seeing very many cases now, well over a decade into widespread use of AI, right? This AI is not new. So, but let's talk about it. One of the reactions I get a lot of time is, well, if we use it, a lot of the same things people said when electronic health records came in. Well, if we decided, I don't know if I'm going to go to that expense. And I don't say this being insulting, but a kind of nonsense, really. AI is here and it will be everywhere. And here's some good examples, right? The one on the bottom right's Iowa, right? The Primary Care Association just got a federal grant for the community health centers to implement AI systems to improve treatment and tracking, right? That's in your own state, and that's just one example in your own state, right? But here, there's two bigger ones out of New York where you see it going whole hog, right? Because there's a split in this country, red, blue split, whatever, but a rural and urban split, just as you all know, exists in Iowa and in the whole center of the country, right? So in the urban centers, people are going whole hog in the healthcare industry into AI, right? So you have in radiology, the New York Health and Hospitals, right? So the biggest public hospital system in the country announced his goal is to replace radiologists with AI and just have radiologists review anything particularly tricky that AI identified. Literally publicly said that. You can imagine the radiologist response to that, but that's the thought process going on. More kind of mainstream would be what Mount Sinai did, also a huge system in New York City. They have in their Epic system, they teamed with Epic, which now anyone can do, and have an open evidence button in the chart, right? So you hit open evidence reads the chart and starts helping you diagnose and produce a differential. You'll hear a lot of people like, well, I'll use it for ambient dictation, but I don't want it suggesting a differential. There's people going whole hog on that, right? And I say again, as I said earlier, ultimately, it's always the physician who's going to be responsible for the differential, the treatment, the diagnosis, what have you. But the use of AI isn't going anywhere, right? And it is going to permeate your lives because it's going to keep getting cheaper and easier to implement, even in the rural critical access hospitals, even in rural practice. So what's going to set the standard of care with respect to AI? Really no different than what sets it now, right? Existing standards of practice. AI identifies whatever condition. Well, that condition has existed for, several thousand years of human existence and several hundred years of organized medicine, and there's a way to treat it, right? So that's still going to be the case. AI isn't really inventing new ways to treat per se. I guess in some ways it might be, but for the most part, it's assisting with diagnosis and implementing existing treatments, right? So then professional society guidance and certifications, which are really starting to come online. The radiologists started it, but you'll see a lot of people are following. What's the medical literature say? What is the FDA approval for the use of the AI, right? You need to make sure you're tracking that. Whether AI is going to allow the equivalent of off-label use similar to pharmacology is kind of an open question now. So that's going to form it. What are the manufacturers saying of how the equipment should be used if it's a piece of equipment that incorporates AI? And then what we talked about before, what are the statutes and regulations saying you have to do or not do with AI? You have to be aware of all of that and get that captured in your use of the AI. right? So let's talk about professional standards because first things first, you need to be aware of what your professional society is saying, right? In every professional society guideline, we'll try and start with, ACOG was a leader in this, when I started in practice 30 years ago, of putting in, their ACOG guidelines. This doesn't establish a standard of care. Well, that sounds good, but in the courtroom, they are absolutely the plaintiff attorneys try heavy, and constantly to use them for just that purpose, right? So you need to know what your professional society is saying. The American College of Radiology was first to come up with guidelines. How are we going to use AI? How are we going to audit the use of AI? How are we going to improve the use of AI? How are we going to study it? How are we going to make AI centers of concentration and excellence? They really, because still to this day, 80% of AI is in radiology. So they were first and heaviest users and will remain so for some time, right? And so their program, which just came on a year ago, is the most organized. However, all of these other ones you see, plus others, either together are developing guidelines or individually developing guidelines. And they're all over the map in terms of how guideliney they are, right? Some are here's our sort of moral statement on the use of AI, or here's our statement that AI will never replace physician judgment, to much more like the American College of Radiology is here's how you should actually technically use AI and not use AI, right? So whatever your specialty is, keep on top of what they're saying, right? Because you are going to be held to it, or at least they're going to try to hold you to it. So make sure you know that. Let's just give some examples of how it's being used, right? And you all know this, right? But so there's over 1,000. Really, this is probably more like 1,200 or 1,300 now. The FDA has approved that many AI algorithms, about 125 new ones a year still. Still 80% radiology, 10% cardiology. Gastroenterology is turning up their pace of use and acceptance, and then it's spread widely across other specialties. And these are diagnostic algorithms, I should say. Like everyone's using ambient AI across all specialties. There are some AI that is not specific to any particular specialty. Everyone's using it. I'm talking about the diagnostic use. So these are just a list, and this is mostly radiology. All of these are at least 10 years old, right? So it's not new. It's been around, as many of you know, obviously been using it, right? So here, the top example coming on is like the old school, oldest use of AI is EKGs, right? That's AI. That top thing printed out is AI deciding, is this a normal or abnormal EKG, right? There's radiology showing AI identification of something needs closer inspection. Same thing in gastroenterology. And gastroenterology in the past 5 years in particular has really exploded in AI and has really demonstrated increased pickup of small polyps that might have otherwise been missed in particular, right? So it definitely is coming online there.
Mr. Jones, we have another question in the chat.
Sure.
Okay, how do you feel about OE having documentation now without ability to not have it and having your end users utilize OE? Uh, with
I'm
this,
not sure I understand that.
um, hold on.
You can shout out the question too if you want to
Yeah,
come
hold
off
on.
mic. It might be easier.
Yeah, this is Clyde Grady. Thank you.
Sure.
Previously, we had OE through Network, and now that OE has added the ambient documentation, our compliance division is uncomfortable with that, knowing that we may have end users utilizing that documentation despite being told not to, and entering in PHI. So we have essentially blocked it from Network. So to see an organization like Sinai feel comfortable doing that, how should we feel about that?
Um, I mean that is if you're going to use open evidence, right? And it's going to generate a differential that's going in the chart, you had better be darn careful, underline darn, as to why you chose what differential you chose, diagnosis and treatment you chose, because you've kind of jumped ahead, which is not, I'm not saying that in a pejorative way, to the exact issue, right? That where we see liability coming is you used AI and didn't follow its direction, right? That's basically what you're talking about. You used open evidence and it said something you didn't follow, and it turned out it was right and you weren't, right? That claim is coming. So, but there's going to be a dichotomy there. People say we're not going to do that. We're going to rely on our own differential, just as we always have, versus the people who use open evidence as Mount Sinai is using it. If you're going to use it, you have to document, as you should anyway, right? That's not news, why you picked their differential and why you think this is the diagnosis, right? And this is your course of treatment. You just, if you're going to use it, you have to very carefully document why you chose what you chose to minimize or avoid that attack of, well, look, open evidence said you should have chosen C and you didn't, and it turned out it was C. So that's the answer I would give you on that. On your ultimate question, which I think is, should we be using it or not? That's like just so totally up in the air. You know, because in some ways we feel it can reduce liability by broadening the maybe picking up something you didn't think of, right? Which I'm not saying to be insulting, but it might, right? So there is no gold standard question of should you use open evidence as part of your treatment or not. I will tell you that in our observation, this is very anecdotal, not scientific. I think it's going the way of Mount Sinai, right? Because here's the thing, the kids coming out of training and everyone trained at Mount Sinai, everyone trained at New York Health and Hospitals or any big urban system, they're all using open evidence, these residents, right? And they're coming out into private practice, and we increasingly see, like I just gave a talk to a bunch of residents yesterday, that as they're choosing in their postings and where they're heading, they want hospitals and practices that are as AI forward as possible, right? The young generation of upcoming physicians are going to insist on it. And so I think that is going to guide its use, frankly. And that's why, our feeling is we're in for a penny, we're in for a pound on this AI. We just have to stay on top of it and spot, from our perspective, the liability trends and try and help you all stay ahead of them. So I don't know if that answers it really, Clyde, but I don't know. I can't give you the black and white answer, unfortunately.
Dr. Grady, do you have any follow-up questions relating to that?
No, I appreciate that. I think that part of the question had more to do with my compliance's fear that because the product has the ability for an end user to use documentation, despite the fact that, we give them Epic to do it, but, it's kind of like not wanting to walk outside when it's raining because you're afraid you're going to get wet. So, right. Is that just a very fearful compliance officer, or what's your feeling on that?
When you say end user, you're talking about your provider, not the patient who's accessed their chart.
That is correct.
Right. You're talking about your provider using it, and your compliance officer is worried of the provider using it for what reason? That they're getting bad info from it?
No, just that they're using the ambient documentation portion of it within OE.
So the ambient documentation, I'm sorry, I totally misunderstood your question. I was more concentrating on use of OE and how it might walk you into a trap or what. But if the question is your compliance officer is afraid of the use of ambient dictation software, that's, again, I think everything is going that way, right? And the biggest, and we're going to talk about that, the biggest threat of ambient dictation software is people use it and don't double check it. It's no different, we look maybe roughly the same age, that when you came into practice, the people still used maybe live transcriptionists or dictaphones, right? You had to review your transcription. Right. You still have to review the ambient transcription, right? So that hasn't changed. So our view of the ambient transcription, it is not going to increase liability unless people don't review it. And if you don't review it, it's no different than it's been forever, right? There's no change in that regard, in our opinion. And so, but then what we do see with the ambient, if the ambient dictation then has the functions of open evidence or other Epic functions on it where it will generate a differential in the ambient dictation, then again is where you just have to review and dictate carefully your choice, right? But my response to the compliance officer would be, it's almost like I liked that's like saying I won't go out in the rain because I'm afraid to get wet. It's here, right? And everyone's going to want to use it. And it does save a lot of time. Anecdotally, what we get, the quality of life, the reduction in pajama time, so to speak, with use of ambient AI is a real thing. So.
Great. Thanks everybody for your time.
Sure. No. These are great questions.
We do have another one in here, just briefly. Do you have thoughts on artificial intelligence differential diagnosis, or AI DDX, versus phase DDX?
I don't know that I know the phase. I don't know what you mean by that. I'm not familiar with it, so I can't answer that question.
Okay, we can follow up afterwards.
Yeah, if you think about it, because we may be talking about the same thing because the terminology is so different on different systems, even, right? That I may not have heard that one, but I know exactly what you're talking about if it's a different name. Anyway, this is just like to show GI procedures, right? There was a 50% reduction of missed polyps using it. What's coming too is just, operations. Are we going to see, it making operative decisions or being able to actually perform operations? Da Vinci is going there. They're not there yet, but they're going there, right? And one of these first steps towards it was they put 8 or 10 cameras in operating room and had the AI dictate the operative report, and it was far more accurate than the surgeon, and just dictating that. And so that's kind of the first step of if the cameras can accurately look at what's going on, can they then develop the technology to have it actually perform remote surgery itself? That is being developed. So where do we expect diagnostic AI liability? We know, given the widespread use of it in our cases, it must exist. Just take radiology, and if there's radiologists on, I'm not picking on you, but it's widespread, right? The statistics say 3-4% of all radiology films are misread. If it's retrospective studies after you know the diagnosis, that goes up to 20 or 30%, right? 80% of radiology cases are misdiagnosis cases, misreads. And so, if you just do the numbers of our actuaries, just run the numbers, we know some percentage of it is use of AI because more than half of radiology films now are read with AI. There's some percentage that the AI misread it or the radiologist relied on the AI improperly. Again, though, it's so hard to tell. Right? What do you know that the radiologist looked at? It doesn't have a recording of the review of the radiology film. It's very difficult for that claim to be made. So what we see in future dangers isn't so much is like skill erosion, right? People, particularly the young people coming out who have become very reliant on it, very reliant on open evidence, either don't develop the best critical thinking skills or they have skill erosion the more they use it. I will tell you, we see that in law for sure. No doubt. Our legal AI is breathtakingly good, but if you let it, it would do all the thinking for you and do it damn well. And so we do worry about what about these young kids? How are they going to develop the skills? How are they going to develop the skills to know the AI is wrong, right? So we see that as a source of future liability. Documentation of training, of people using AI, were they properly trained on it? And then products liability, right? Well, who's going to get sued? The physician is the learned intermediary using the AI or the AI for being a bad product? All of that needs to be still fleshed out in the legal system. We do think also you're going to see failure to use available AI, like this gentleman. Clyde, I only have your first name. I'd hate to be calling you Clyde, but you failed to use AI that was there. You failed to use open evidence. Open evidence would have shown this, and you didn't see it on your differential. That claim is coming. The way plaintiff attorneys work, you're damned if you do, damned if you didn't, right? If you used AI and it went wrong, you shouldn't have used AI. If it went wrong, you didn't use AI, AI would have saved the day. That's just plaintiff attorney 101, right? It's not a search for truth, this process, right? It's a mercenary affair. And so they're going to argue it whichever way works, right? And so it's going to go both ways. And then again, just what I was alluding to before, the AI suggested differential diagnosis or a path of treatment, and you chose something different, and it turned out the AI was correct, right? That doesn't, let's just step back. In the medical malpractice arena today, before AI, the choosing the wrong thing on a differential, as long as it was done with judgment and following an algorithm, isn't negligence. You can make a wrong medical choice and it's not negligence. And in fact, in most states, the juries are instructed that, right? As long as you can demonstrate you made a reasoned judgment, that in and of itself isn't negligent, right? But they will try and bootstrap that argument anyway with saying, well, you had the expert AI and you ignored it. That will come. So let's talk about the generative AI. We just have a few minutes left here. Well, we got one or two. The physician scribe, what we were just talking about, right? It is a big time saver. People report anecdotally, many of you are using it, better patient interaction. So as a lifestyle, it's been a positive thing, right? But again, we just come into, you have to proofread the notes. You cannot rely it. And the one thing, please, 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 if your ambient AI system has that disclaimer at the bottom that says this note was generated, because Dragon will have it too if you use Dragon. This note was generated by Epic AI or what have you, and any errors in it are attributable to the AI. People think that gives them an excuse not to take the time to read their note, thinks that is going to be a defense to a medical malpractice claim. It is exactly the opposite. All of this software has the ability to remove those disclaimers. Our underlying strong recommendation as a medical liability carrier to reduce your liability is to get rid of that disclaimer and make sure you read every note, right? Because those disclaimers actually are a weapon for the plaintiff attorney at trial, right? The jury sees that and the jury sees lazy doctor, right? There were obvious errors in this chart and you didn't take the time to read it. And if you didn't take the time to read it, did you really take the time to see the patient? Did you really take the time to consider it? Or did you just rely on AI for everything and you didn't really do much by way of treatment? That's the kind of thought process that the plaintiff attorney will hammer on with the jurors. And so get those disclaimers out of your life if you want to reduce your liability exposure. Last thing I want to talk about is what we call agentic AI. And again, when you're talking about the terms for the types of AI, people don't agree on that either. When I say agentic AI, what we're talking about is AI that can provide the treatment with no human involvement. It's here in a limited fashion and it's coming. So let's talk about it. So what's here now? What the FDA allows now is what they call a closed loop, right? And so that's variability of outcome is low and the outcome is very tightly measurable. So there's very little chance for an outlier or something to go really wrong. So what are good examples of that? Glucose control devices, pacemakers, ventilation pressure machines, and infusion machines, right? Those are all using autonomous AI that is not with each infusion or each decision the machine makes, there's no human involved, right? You know, there might be checks periodically, but not on a day-to-day or moment-to-moment basis, right? So those are agentic AI. Those are autonomous AI operated machines. The futures are going to be the FDA. You know, there's a lot of pressure on the FDA, and the FDA is doing a lot of investigations to increase the amount of autonomy, increase the scope of the autonomous decision making and treatment allowed. So the other big development in the past few years is what we call the sandboxes, right? The AI sandboxes that allow for use of AI devices and experimentation with AI devices and limit liability for bad outcomes, right? And try and tightly control what can be done, right? So there's a wide split in states of use of these and implementation of them, and it is still very much in its beginning stages, right? Utah is leading the way. That's why I have this as an example. And just they approved their first couple this year. Autonomous prescription renewals, right? There's one Doctronic that has 190 medications in its formula that the computer decides whether it will renew based on an online renewal application sent in by the patient. No human involvement. And it's a tightly controlled type, but that includes SSRIs, right? It includes some psych meds. Then the Legion one is solely psych med renewals, believe it or not, right? That they're allowing. And so it suspends the Board of Medical Examiners authority for the use of that sandbox device, and it limits liability, right? So it is a new horizon for sure, right? The split in the states, I mean, you could kind of say it's red-blue. I mean, I'm not trying to get political, but it sort of is, right? So like Colorado, New York, California, very blue states take the opposite. They very much want to control use of AI and limit its use and limit its autonomous abilities. Whereas other states, Utah, Texas, Wyoming, Arizona are trying to expand it. But Utah's the furthest down the road. Interestingly, however, you all introduced in Iowa this year the most aggressive sandbox that's ever been proposed, right? And it actually got into committee. It didn't get passed though, but it got introduced and made some traction. And here's why. And that's also why you see some of these other states with heavy rural population. It's the same reason you see a push to expand scope of practice of advanced practice providers, physician shortage, care shortage in rural areas. And that was the impetus behind the Iowa sandbox bill, I'll call it, that came up this year and didn't make it. Right? It was to create a separate board of autonomous medical practice, and autonomous medical practice being no human involvement. So the board of medical examiners wouldn't be involved in this, right? It had various levels of autonomy that far exceeded Utah's, right? It allowed for obviously direct patient care and interaction with the computer system with no human involvement, right? The pros were, again, that this could be implemented in rural areas and at least provide some care with the, it's kind of, and I don't mean to be pejorative, but it's the same thought process with expanding APP care in rural care, areas is at least there's something, right, available, even if it's not what ideally maybe everyone wants. The other thought was if you allow these sandboxes, you promote medical device innovation, which is probably true, but you see the cons is obviously patient safety. Who's accountable, right? Like, what if something goes wrong? Is it like who is it the manufacturer? How protected are they? And then does it conflict federally with the FDA's ultimate authority to approve medical devices, right? Is it state, jumping federal supremacy? And typically it is federal supremacy. But the fact that it was introduced means you could certainly see it again. I don't know that. I don't have any like inside baseball. Is it coming back? I don't know that, right? We do a lot of Iowa regulatory things. For instance, I was heavily involved in third-party litigation funding and things that directly affect the liability side of things. Tort caps, that kind of thing. So I don't know where this is going to come back. I haven't gotten any inside info. I would give it to you if I had it, but so I don't know if it will. But the fact that it did and the fact that it's increasing everywhere, some version of it's going to come back in Iowa, right? Because particularly, again, the rural healthcare crisis is driving a lot of these, and you have that just like so many other states, particularly in the middle swath of the country. So that's like an overwhelming number of topics in AI. That's what I have, and happy to answer more questions. Or if you want to email in follow up, your phase one question there, or phase DBX rather, please do, and I'll get that answered. But I just wanted you all to be thinking about these things. As you're seeing, you ironically, use your ChatGPT, use your AI to keep track of what's the Iowa sandbox doing, right? What's my professional society saying, right? Your AI is going to help you stay on top of it. So use it for that, right? If nothing else. But you see, just your points of potential pain. That was the purpose of this, to identify and just so keep your eye on the ball. And obviously, if you're an insured with us, you can call us anytime. If you attended this talk, you can call me. I'm happy to talk to you. But if you're an insured, you can call in anytime with any question about AI or anything. We have the lines are literally open all the time on these questions. So with that, if you have any questions now, I can hang around as long as you want. Otherwise, I will bid you a good day.